Our next speaker is Adam Chamberlain, and again, I think this is the second time I've used Adam for participation. But Adam was also very helpful to me when in one of my previous guises as a VP Exploration for Queenston, in helping us walk through a lot of the issues that we were looking at in terms of negotiating and consulting with our Aboriginal communities in northeastern Ontario. That was an interesting process for me because the identified Aboriginal communities grew from 3 to 7 in the 3-year period based on ongoing assertions. So check back regularly in your consultation process. Adam is a partner at Borden Ladner Gervais Toronto office and the national leader of the firm's Northern Practice Group. Adam is a member of Nunavut and Ontario bars and a certified specialist in the area of environmental law. He's active in BLG's mining and Aboriginal practices and has worked for many years on matters where the two areas intersect. He's advised mining companies and others in the mining sector in matters ranging from Aboriginal consultation to the negotiation and implementation of impact benefits agreement. Recently, he assisted the government of Nunavut in the environmental assessment processes for the Mary River Iron Mine, as well as the Dominion Diamond, formerly Harry Winston project, and its purchase of the Acadie Diamond Mine in Northwest Territories. Adam is also very active and very proud of his work with Camp Awakening, which is a charity that sends children with physical disabilities to summer camp in a setting that integrates them with able-bodied children. And Adam is going to talk about the black box of impact benefits agreements today. Adam? As soon as I get your black box.
No, it's good.
I'm getting better at this.
You're getting very good at it.
Okay, it's working.
Thanks very much, Bill. I always really like it when people read the last bit of that introduction, because it's the volunteer work that I do for Camp Awakening is lots of fun, and we get to see some great results for kids with disabilities going to summer camp in Ontario. Anyway, so as Bill mentioned, I'm going to talk a little bit about impact and benefit agreements. There are, I'm sure, some of you in the room who have a great deal of experience with these agreements, and some of you who probably have never seen one before or don't have much experience at all. So I'm afraid I won't be able to suit you both bang on. You'll probably both come away wondering why I didn't say more or less. So apologies in advance. But what I'm trying to do is, I'm going to try and do is just talk about some of the key issues around impact and benefit agreements. And actually, when Bill first got in touch with me, he framed it as the Holy Grail, and IBAs as the Holy Grail. And I was at this conference, that you've heard of already, Canadian Aboriginal Minerals Association, yesterday, and there I spoke on this same subject. And there I called it something to do with the black box. IBAs, the black box. So I'm going to do a bit of both. And would contrast the notion of the IBA as a black box with the notion of the IBA as the Holy Grail. But first, of course, I'm a lawyer, so I have to start with my disclaimers. They're not terrible, but I still have to let you know. They're sort of disclaimers and sort of information. I have the great privilege of working for and having worked for sort of all sides of this piece. As Bill mentioned, I've worked for the government of Nunavut on a project, so there I'm acting for the Crown, or, well, it's not technically the Crown from a legal sense, but it is a government. I've acted for industry. In one case on the purchase of the Acadie Diamond Mine is a fairly recent example. And I also do work for Aboriginal organizations, and this is where my practice is a bit weird, I think, in that not many people I know who work for industry or government end up working for Aboriginal organizations. I do, and the reason I do is because I'm a project lawyer. I'm about getting projects built, permitting and approvals. Aboriginal consultation and IBA negotiation and implementation falls into that bucket of project stuff. So when Aboriginal communities are the proponent of a project, a power line, for instance, one good example was a project, not a mining project, but an energy project where an Aboriginal entity called Five Nations Energy built a transmission line that extended from Moosonee up to Attawapiskat and then into the Victor Diamond Mine. So I was part of the legal team that did that, and you can probably guess the bits that I might have been involved in. They were environmental assessment and things like that. But the reason that helps me with my practice is it allows me to have viewpoints that are somewhat perhaps schizophrenic, and since my dad's a psychiatrist, maybe that's a good thing, and not surprising, perhaps. If you know psychiatrist kids, they tend not to be all that normal. But what it does do is it arms you with knowledge of what the other people are thinking. And frankly, if you can come to a negotiation understanding what the person across the table might be thinking about, you're going to be at somewhat of at least a bit of an advantage. You're going to be better off than you would be otherwise. And I've already mentioned some of the mining projects I've been involved in recently have been in Ontario, Northwest Territories, Nunavut, and Quebec. A few outside of those areas as well, but those are my areas of principal activity. And when I'm in Northwest Territories or Quebec or other provinces, typically we retain local counsel to help us out with local issues. In Nunavut, there are no local counsel. Well, there are a few, but they do criminal and family, and that's it. If you don't have local counsel, then you become a local lawyer. So I'm called to the bar in Nunavut as well as Ontario for that reason. And this, just to full disclosure again, this presentation does not reflect any of the views of my clients, although they might have elements of them hidden in this thing. I feel sometimes I should just make that very clear. And when I say IBAs, I'm not just talking about IBAs. I'm talking about agreements that confer some sort of benefit and perhaps deal with impacts of projects. And I was at a meeting not long ago with a mining company, and another mining official from a competing company who happened to be at the meeting stood up and looked at me and said, "Well, we don't have IBAs," in this very condescending tone that I can't replicate right now. And I thought, "You don't have IBAs?" I knew he did. He said, "We have resource revenue sharing agreements." And I thought, boy, that sounds really impressive. I've now seen those agreements, and they don't do anything differently than the particular IBAs that were involved in that discussion. So the name doesn't really matter. It's what the agreement does, and if it deals with impacts of a project on a community or their rights, and also the corresponding benefits that they might receive in exchange for those impacts, that's what we're really talking about here. But it also moves into the realm of joint ownership, joint ventures, things like that we're seeing more and more. And there is an evolution that I'll talk a bit more about. So is this the Holy Grail? Is an IBA the Holy Grail? And the reason often it's seen as the Holy Grail is if a community has an IBA, it means they've got a project, usually. It means there's something that's happening, some economic activity that's happening either in or near their community that they're going to get some benefit from. So communities that don't have IBAs, they probably want one, and that probably means they also want to have some sort of economic activity, whether it's a mine, an energy project, or something else. So they see it as a source of wealth. It's seen as beneficial for that reason. It's also seen as a form of leverage, because if you have an IBA, usually that confers some sort of power or at least some ability to have some sort of economic roles in projects and employment creation, things like that. And it goes a long way to reflecting a community's desire to have opportunities. And so, again, another thing that Bill and I talked a little bit about as we were talking about this presentation was, what is an IBA? Is it really, is it really something that's more about opportunities? And I think, to be honest, it is. That it either provides opportunities or describes them or reflects the potential for them, and we'll talk a bit more about that in a minute. And I think what makes these things look like the Holy Grail is that most communities don't have the good fortune of being on top of a diamond mine or on top of a gold deposit or right beside with a run of a big nice river with waterfalls that could be dammed and made into a run of river development. So if you don't have the resource, it's not going to be, this is not the kind of thing that's going to come easily. So for those reasons, I think these agreements are, in a way, the Holy Grail. Now, back over to the black box analogy, this is the one I was using yesterday, because generally these IBA agreements and other ones like them aren't available to the public. Typically they're confidential. And they're confidential for a bunch of reasons. Competitive reasons on the industry side, and by the way, if you're interested in this after I finish and you would like a copy of the presentation I did yesterday, it has more detail about this. So if you want it, just send me your email or give me your card and I'll send it to you. And I say that because I had a couple slides on the competitive reasons on both sides of this, the discussion. But so if you want that presentation, it's much longer. I was talking for an hour and a half. But I'm happy to give you the slides so you don't have to listen to me. The competitive reasons, you can see it on both sides. From the business point of view, you're conferring a benefit, you're setting a price tag, you're setting the bar is being set here, and if that information becomes public, well then, the next community you deal with, they're going to know that's the bottom, right? That's the cheapest it's going to be, and really they're going to want more. Conversely, if you're the Aboriginal community and the bar is set here, that becomes the ceiling potentially. That's the deal that some company got, so why would why would another company settle for giving me more? You can see that this becomes just a game about where the bar is and trying to adjust expectations. So there is a benefit for confidentiality. I'm not suggesting that it's the way I think things should be, but you can see how varying interests would not want to share this information with everybody. And that is an issue that I think we see more and more of, and have seen more and more of. It's starting to change, and I'll get to that in a second in terms of what we're seeing. Some stuff will probably always be confidential, but not everything needs to be confidential, and in fact, not everything is confidential when it comes to IBAs in Canada, at least what they look like generally. So, and final comment there you see on the slide is, does it really matter what's inside, or is it what happens as a result of the agreement? Does the IBA and its provisions, the list of provisions in it, and these are massive documents often. I was carrying one with me yesterday just as an example, and it's, it's a small phone book, certainly bigger than Prince Edward Islands. So, these are, does it really matter though what's inside it? What really matters, I would suggest to you, is what the result is. Do community benefits reflect or offset or mitigate the impacts that a project is having on them? And the important thing about an IBA and creating a successful one is that you always hear, or I often think, that if neither side of a negotiation is happy with the arrangement, well, it's probably a decent arrangement. IBAs, you hope it's the other way around. You hope both sides are happy with it, and then that's an example of a good IBA. But you can get the picture. It's never going to be something that everybody is entirely satisfied with. So there are many reasons why these continue to exist. In early times, and Mike already suggested to this, or referred to this, that prior to a lot of the most recent case law on these issues, on Aboriginal rights, people were entering into IBAs. The IBA for the diamond mines in the Northwest Territories, were done around the same time the IBA, or the mines were created in the late 90s, relatively recently by mine standards and IBA standards. But it was before cases, well, about the same time as Delgamuukw case, which is a famous Supreme Court of Canada case that spoke to these issues, along that as the case law has sort of been evolving, but well before the HIDA decisions, HIDA and related decisions that really set out a lot of the requirements for consultation and accommodation. So just because the Supreme Court of Canada has been coming in, more recently, it doesn't mean that these things haven't existed and haven't been reflected in IBAs. So anyways, we've got the one, it's the right thing to do, and the first project I ever worked on and negotiated an IBA for was actually one that Bill's second cousin, Gordon McGinty, was Bill's relative.
He was a dump guy.
He was a dump guy. He was my client. He was a great man. He is a great man. And and Gord is a developer. He was aggregates and garbage, and he wanted to take an old open pit iron mine, which I have an affection for because it was called the Adams Mine, near Kirkland Lake, and he wanted to convert it into a garbage dump to take Toronto's garbage. Some of you might remember this happening in the late 90s. It got into the press. Anyways, I negotiated an IBA for him for that project. It never was actualized. It never was realized because the project never got built, so no money ever moved. But Gord was doing it in the late 90s because it was the right thing to do. It was not tied up in legal requirements. Community initiatives also drive these things. If a community near a potential resource wants an IBA, well, guess what? You're going to get one, or they're going to get something. The question is, how do they try and do that? And that's when we work with Aboriginal clients. That's the trick, is how do you get that to work? Building relationships. Again, if you're on the business side, the more relationships you have, the better you are equipped to avoid conflict and to get your project off the ground. And more recently, the courts say you have to enter into IBAs in certain circumstances. And I'm going to talk in a second about modern land claims because they are also a source of a requirement for entering into impact and benefit agreements. And the nugget, I've already got to this, but cooperative efforts will result in more success, for business and for the community. So the IBA is a principal tool to create the environment in which business partnerships can be formed and actually realize benefits for communities. There's lots of other reasons too. I'm not going to dwell much on the confidentiality versus transparency issue. I've already talked a bit about the rationale for confidentiality, but we are moving towards a place, and Leslie, I think, is going to be speaking about this very soon, so again, I'm not going to tread on her area. But there is new legislation that's come, or is being proposed, and that's going to impose more reasons for transparency of IBAs and the information behind them, mainly the money. That's something that is coming, and there's a bit of we have a transition period coming up, but for a couple of years while we wait for this legislation to apply to Aboriginal governments. But the one question I've got about this, and before I move off the topic and change the slide, that I'll leave with Leslie, is the legislation as proposed talks about Aboriginal governments and the payments that might be made to Aboriginal governments. There's no definition of Aboriginal government in the draft legislation. So I've already been asked by a client, what does that mean? And I don't have an answer. So it'll be interesting to see where that goes. I have recommendations, but I don't have an answer. So modern land claims, I want to bring it up because it's a really interesting tool or place where you see requirements for impact and benefit agreements. And the one I'm referring to here is just one of several in Canada, and it's the Nunavut Land Claim Agreement. On the right there is the Inuktitut cover of the copy. And if you can get a chance to look at it online, it's quite a neat, actually, graphic there. It's I believe it's by Kanujuak Ishevik, who's died last year, a very famous Inuit artist. And it shows the 6 Inuit seasons in that on the cover, so it's worth taking a look at. But Article 26 of the Nunavut Land Claims Agreement says no major development, you can read it, may commence until an IBA, and the reason there's 2 I's, it's not a typo, it's because it's an Inuit Impact and Benefit Agreement, may commence an IIBA is finalized in accordance with the article. So you can't build your mine without one of these, without an IIBA. So the courts, who cares? In Nunavut, the Land Claim Agreement, I consider it a quasi-constitutional document because it actually creates the institutions of public governance in Nunavut, and it requires it. So there you have it. It's nice and clean. I want to tell you about this because the black box question is, what's inside an IIBA or an IBA? Not always an easy thing to answer because most of them are confidential. But one good example, there are others, but one very good example and recent is the Mary River project. Its IIBA is actually available on the web. So there's the web address for QIA. QIA, by the way, is the Qikiqtani Inuit Association. It's the regional Inuit association for the Baffin region. And on their website is the IIBA. Now, you'll look at it, and if I didn't tell you this, you'd look at it and curse me, because when you look at the thing, it's quite long and you can print it off. All the numbers, the dollar figures are redacted. So as I said before, right, confidentiality and transparency, there's going to be, it's not just one or the other, it's going to be a bit of a spectrum. And, that's a good example of, frankly, most of the meat is public. So you can see, and I didn't reflect it in this presentation, but the one from yesterday does have the like 20-odd points from the table of contents. So you can get a sense of what it's like, or you can read the document itself if you're interested. But the black box isn't completely as closed as it was in the past. Now, most IBAs, especially the old ones, are not publicly available. This is a good one. It's not perfect, and it's not going to be the same as all IIBAs or IBAs you see elsewhere, but it's a really good template. It's one that, if you want to get a sense of what an IBA should look like or might look like, this is a good place to start. Evolving case law. I'm not going to dwell on this. You've heard about it already, but it is the case law is driving where the negotiation of IBAs and similar agreements goes. There's just the sites, so you can find the cases if you have the interest in have some insomnia and you want to read them. But what's the impact on negotiations? Well, I think a couple key points to take away from those decisions. One of them is the Grassy Narrows, which is from Ontario. It's sort of a maintenance of the status quo, but as was already mentioned, the case, the Silcotin case, really is quite revolutionary in that it's a case where there's, you've got the declaration of Aboriginal title. One of the key point is only one judge on the Supreme Court of Canada is a pre-Stephen Harper appointment. And I think a lot of people thought with the Conservative governments that you'd start to see decisions changing and that maybe you wouldn't see continued movement like this with increased Aboriginal rights being declared. All but one of those judges, is a Stephen Harper. Well, all but one. Yeah, the 8 are Stephen Harper appointments and 1 is not. and it is a democracy, right? So if 4 or 5 of them didn't like what was going on, they'd change it, and they haven't. So I think that tells you something. These are unanimous decisions. The pendulum is going to continue to swing out towards Aboriginal rights. This is not going to change anytime soon. And these cases don't introduce revolutionary topics. They are just continuing on the evolution that has already been set by the Supreme Court. So I think what we're going to see, and the key point to take away, I think, no matter what side of this equation you're on, is that the impact that this creates, whether you're in BC where seal coating really applies directly and explicitly, or if you're in Ontario where it might apply, or my argument is it does, but even if you assume you're in a part of Canada where you don't think Aboriginal title is about to be awarded by a government or declared by a government, the expectations of the Aboriginal communities are certainly rising, and they're going to expect more and more in the future, I think, as the court continues to do these sorts of things. So the Holy Grail, as I've said here, is more attainable. The black box is a little less mysterious. And I'll finish with a few slides. I'm going to move through these fairly quickly, but I like to do this. First of all, the black box, it's hard to see it, but on the bottom right there, that's from 2001. That's when they uncovered the black box with a monolith on the moon. And if you've seen the movie, you'll recall being mystified what the hell was going on, because at this point, I mean, throughout the whole movie. But at this point, there was a screaming noise, and these guys obviously uncovered something that they might not have wanted to. So the black box being uncovered can be a bit of a mixed bag, right? And the guys on the top, you remember Monty Python, they never find the Holy Grail in the movie. They get arrested by the London police. But on the way, they run into some trouble, and you'll see that he's missing a couple arms there. So I'm going to thank you, and then I'm going to show you a few more slides just quickly, because they are quick. But Kayanamik, that's Inuit for thank you, and my pronunciation's not great, but and that shot's from sitting outside of a Iqaluit on Frobisher Bay. This is a very strange thing that I put there because it was a snow formation I saw last spring in April. It's the only time I've ever seen an arch of snow created by wind, so I do share it with people. This is my hobby. You get a sense of it. It doesn't have anything to do with the presentation. I just like the picture. But I'm going to talk to you ever so briefly about the importance of Inuit Kwayamaya Takanji, which is Inuktitut for Inuit traditional knowledge. Again, with apologies to any Inuit in the room, my pronunciation's not great. But you see this fellow's wearing sealskin because it's warm, and it works a lot better than even the warmest down coat. But the reason I'm showing you these slides is the next 6. It's just it's a quick show. This is at Tunic Time, which is the spring festival or the Return of the Sun festival in Iqaluit, and it is it's probably the only spring festival in the world, or maybe one of a couple, where there's a igloo making contest. So this is the igloo making contest, and you can see this fellow is standing in a hole that he's just dug, and it's hard to see them because it's so bright and washed out a bit, but there are blocks of snow right around him, and he's cutting them out. And it's quite wonderful to watch, actually, because what he does is he cuts them out with a saw, and then he shapes them with a knife. But when he cuts them out with a saw, they're not really square, they're trapezoids, and they fit together. And as he does this, he's able to stack them. And here he's gone around one ring. The next couple get better. As he does it, frankly, as he's lifting them out of the ground, he just shapes them by putting handles. So all these blocks have handles on them, so he's easy to move. And then you can see it's kind of like a spiral. He's now moved all the way around, and again, you can start to see how they're leaning on each other. And he keeps doing that. And here, it's quite amazing to watch, actually, how the blocks all just sort of lean against each other and stay up. Here he's starting to get close to the top. There, we're getting there. And then he gets to the top, and this is one of the neat things. The last block is, of course, a hole, and he shapes the hole to make sure it's the shape. And then he sits a block on top of it. And then from the inside, he goes back inside, and he starts carving out the block from the inside. And as he does that, the block slowly drops into place, and you can sort of see the knife sticking out there and the blocks that are being carved off, and eventually you get an igloo. Really neat because I think it's a good example, first of all, of neat pictures, but also it's a good example of how important traditional knowledge is, and it can be reflected in IBAs. If you can't build one of these things quickly, you can die. And this particular one I watched being built took about half an hour, and there were others there that day during the contest that were being built in 15 or 20 minutes. So if it's 45 below and windy, and the skidoo breaks, this is how you make it. So anyways, that's my presentation. Thank you very much.